Hi, I'm Vivian Dempsey, and we're going over Winter 2014 Performance Test B, which I call ROCK. This is a very classic format in terms of the way they give the issues, because it is 3 cases, 3 issues. And what you're always looking for in a PT is for the problem given by the file to line up with the resources in the library to resolve that problem. And if you can get that sense of kind of a click, almost like a seatbelt going, tongue of a seatbelt going into its housing, then you've probably found the solution to that PT. In this performance test, there were 3 cases. So 3 cases, 3 issues. There were also 3 statutes, and each statute went with 1 case. So the case discussed 1 statute, the second case discussed a 2nd statute, the 3rd case discussed a 3rd statute. Okay, so everything lined up in these 3s. Okay, so here are our 3 cases and our 3 issues. There were, by the way, only 3 hearsay exceptions in the library, so there wasn't any way to get confused here. Okay, so the Hannah case discussed former testimony exception to the hearsay rule. The Bryce case discussed the residual hearsay exception, guarantees of trustworthiness. And the Cabrera case discussed statement against interest exception to the hearsay rule. So those were the 3 issues. And each of those issues was construing, each of these cases was construing one of the hearsay statutes. Okay, so in my method, and this is really more about me teaching you my method of analyzing the PTs, which is the big secret to the bar exam. If you can master the PTs, you can pass the bar exam. If you're an attorney bar applicant, the performance tests are 40% of your score, just the 2 PTs alone. Okay, if you're taking the general bar exam, the performance tests are 26%. So in any case, you can't ignore them. And because, in my humble opinion, the other courses don't do much of a job of teaching you how to do a performance test, how to analyze it, it's a real source of extra points if you do have a method that works. And I, the Writing Edge, does have a method that works. Okay, so these are your 3 issues, and these will be 3 issue sheets. So let me go through them first, and then I'm going to lay them out on the wall to show you this is what you should have in front of you. You should have the 3 sheets in front of you like you're playing solitaire. Okay, so let me go through them. So the first one is Hannah, okay, and the issue is former testimony. The rule is the statute 804B1 and the Hannah case. Okay, so the 804B1 statute gives you a 2-part test. It's right in the statute, 1, 2. The second part of that statute is that there be a similar motive for the former testimony, that the person who's trying to now rebut this had a similar motive to rebut it the first time it came up at a prior tribunal. Number 1 is a witness at a trial. And number 2 is had a similar motive to rebut. The Hannah case focused right in on the one element here from the rule in the case, the statute, motive. And it added its own test, which is that there had to be a substantially similar intensity of motive to rebut the statement in the prior tribunal, and that it had to be on a substantially similar issue. And the second is that the proceedings were similar. The facts in the Hannah case in terms of the prior testimony were very similar to ours. There was a prosecution witness who was obviously giving testimony against the defendant, and that was what he was supposed to do at trial. And instead, he said, you know what, the police forced me to do this. This wasn't true. They were asking me to perjure myself, and he really wasn't guilty. And that's what he testified to at trial. Later, the defendant, who was obviously found not guilty of the criminal offense, is suing the police for violations of USC 1983 civil rights violations. So very similar. In our case, the witness, Watt, was coerced by the police to give testimony against Rock, the client here. At trial instead, he said, at the grand jury proceeding, he did give the story that the police wanted him to give, okay? But he didn't want to do it again at trial, okay? So he wanted to recant his prior testimony before the grand jury. Okay, so in this case, in the Hannah case, the court said, you know, the motive that the police had for rebutting this guy who changed his story, who recanted, wasn't very important. And so it wasn't substantially similar because they had enough other evidence to convict him. And so the fact that they didn't bother to rebut his to cross-examine him on his recanting wasn't substantially similar enough, and the defendant lost on, the criminal defendant lost in the Hannah case. But in our case, contrast the facts, the only prosecution evidence was the perjured testimony of Watt. And when he recanted, the suit was dismissed, the criminal trial was dismissed because there were no other witnesses against him. And so in our case, the evidence was very, very important to the prosecution, and they would have had a very strong motive to recant, to cross-examine a Watt. And the fact that they didn't, okay, the file discussion on this says they already knew they'd lost the case, and they knew that the police had screwed up, and they didn't want to put anything else on the record. They didn't know what else this guy might say, and so rather than cross-examine him, they just folded up their tent and went home. Okay, so even though the Hannah rule is useful to us, even though in the Hannah case our side lost, doesn't matter. The test is positive, and we can use it positively on our facts. So that's the first issue. The second issue is the residual hearsay exception. This is also called the catch-all exception, where if there's sufficient trustworthiness for the statement, even though it's not a well-carved exception, it can still come in. The test in the statute, 807, is a four-part a test for determining whether the residual exception applies. But the first of those is trustworthiness. And the Bryce case zoomed right in on trustworthiness. And it added these factors: that the statement by the declarant was spontaneous, it was consistent with other statements that he'd made, he had no motive to lie, the reason for the witness's unavailability at trial this time, and that it was voluntary. In our case, the Watt, after he gave the grand jury testimony that he was so upset about because he had lied, perjured himself, he called his lawyer, because he had a criminal record too, and he called his criminal lawyer and left a message on his voicemail. And in the voicemail he said, you know, I had to give this testimony at the grand jury, the police forced me to, I don't want to do it at trial, I'm really upset about this, and left it on the answering machine. Okay, so his statement was certainly spontaneous. You could hear the upset in his voice, and it was not at all contrived. Contrast that to the facts in the Bryce case, where the statement was made many, many months later, and it was rehearsed. Okay, here the statement was 2 days after the grand jury testimony, so very fresh. So very different facts from the Bryce case. Consistent. The voicemail message, the answer machine message, is completely consistent with his trial testimony recanting what he said at the grand jury, which was given 9 months later. So consistency over almost a year between the two statements. He was talking to his own lawyer, and he had no motive to lie. He was trying to get advice about what to do in face of the threat by the police if he didn't cooperate with them. Why he's unavailable? He's dead. He was caught in another crime, and he was killed during the commission of that crime, burglary, I think. Okay, so he has a good reason for being unavailable. And the statement was voluntary. Yes, he he initiated talking to his attorney to seek advice. Okay, so all of the factors fit. And again, even though the person in Bryce couldn't use this test successfully because of the distance in time and also the contrived nature of the statement, okay, it was not at all spontaneous. In our case, the same factors work positively. So basically what you do is you use the test and you contrast or distinguish the facts as they're given in the Bryce case to our facts. And that's the reasoning. And then the last of the three issues is statement against interest. Okay. This is also called declaration against interest. And the statute that covers it has a two-part test. And the second part includes the element that it be corroborated by other evidence. And the Cabrera case zoomed right in on corroboration and gave a two-factor test, time, that it not have been too distant in time, and the other, spontaneity of the statement. Okay, and in our case, as I said, the voicemail message to his attorney was only 3 days after his grand jury testimony, so a very short period of time, and it was very spontaneous, unrehearsed, you know, the way most people leave voicemail messages. They're very kind of casual about it. Okay, so this test works in our favor too. So all three tests we can use favorably. Now, what I want to show you is how you want to spread out these three issues and see all of them at once in your preparation before you start writing your answer. So I'm going to click off for a minute here and put these up on the wall, I hope.